Hello and welcome to our employment law catch-up, part podcast, part webinar, romp through some recent and interesting cases. My name is Heather Platt and I've been a barrister for 21 years and I specialise in employment and discrimination law. And today I have with me Richard Wayman to talk through a case which we think you'll find interesting and hopefully useful. Our focus today is on Section 15 of the Equality Act. And I should say at the outset that we're talking about a case which involves real people and difficulties at work, which include mental health and neurodiversity issues. Now, we are obviously focusing on the legal issues and the importance of these cases from an employment lawyer's perspective. But we do want to say at the outset that this is a recent case, and we absolutely don't mean to trivialise the significance of how it feels for the people involved. Both employer and employee. Of course, we act for both sides in litigation, for employers and employers, employees and employers, and we absolutely understand that litigation is difficult and challenging for everyone involved. After all, we're talking about the people and the decisions people make at work, so we'll always try to be respectful and mindful of that. So Richard, let me introduce you. You're an employment and discrimination law specialist, joined Chambers in 2015 after spending 12 years running a family business as an employer. So you know only too well the issues that businesses face. Hi, Richard.
Hi, Heather.
And the case that you have picked for us today, could you give us an introduction, please, what we're going to be exploring?
Sure. So this is the case of McQueen and the General Optical Council, and it's an employment appeal tribunal case that was handed down just last month and was heard at the end of last year. And the particular point that arose on appeal related to Section 15 of the Equality Act, and in particular causation, which is always a thorny problem in discrimination cases. So I thought it'd be a good one to look at today.
Great, thank you. So we're looking at Section 15. Could you remind us what that is and what it prohibits?
So Section 15 is the specialised form of discrimination that only applies in disability cases, and it's called discrimination arising from disability. It used to be disability-related discrimination. And what that involves is where it's not the disability itself that's the reason for the treatment that's complained of, but it is something arising in consequence of the disability. So it's sort of one step removed, it's something related to it. And so you end up with, you have this two-stage causation test. The tribunal's got to obviously identify whether the claimant's been treated unfavourably, and notably that's unfavourably, not less favourably. So we're not talking about a comparator, it's unfavourable treatment. The tribunal's got to identify whether that's happened, and if so, who has done that treatment, and then look at what caused that treatment and look at what was in the mind of the person who's supposed to have discriminated. And having established that, the fact of the treatment and the reason for it, then they've got to determine if that reason, what was in the mind of the discriminator, was something arising from the disability. And that is an objective test at this stage, so it doesn't matter what the discriminator thought, it is simply, was that reason that they found something arising from the disability. So it's a sort of two-stage test. And just two other points on that. Firstly, as with indirect discrimination, discrimination arising from disability can be justified. So if the employer can show that it is a proportionate means of achieving a legitimate aim. And the other important point, again, with disability claims generally, the employer must have knowledge, or constructive knowledge should reasonably be expected to have known, but only about the disability, not about the something arising from. And that is obviously tricky for the employer. Obviously, it's desirable for the employee to tell the employer, but the employer doesn't need to know what the something is. They do need to know about the disability. So it's a potential minefield for employers, given particularly, obviously, as in this case, where you've got mental health issues, a potentially broader range of somethings may arise.
Interesting. Thank you. Could you tell us then a little about the facts of this case, McQueen and the General Optical Council, please?
Yeah, so the claimant was a registration officer for the GOC, and there were a number of incidents at work over a period of years, which, and this is using the term that the tribunal used, the claimant had meltdowns, was the phrase that they used, and they tended to involve him and his line manager. And to give you an example of what was meant by that, in the first of those, the claimant challenged an instruction that he'd been given by his line manager. She felt it was a reasonable instruction. He objected to that instruction in a way that she felt was rude and inappropriate, and that his gestures and his body language were inappropriate and aggressive. So that obviously caused problems. There was a occupational health referral, and a number of steps were taken by the employer to try and understand the situation and the claimant's particular health concerns. There was giving another example, there was the second sort of meltdown that the tribunal referred to, where the claimant had actually been asked to pass on some of the backlog of work that he had to colleagues. His reaction to that had ultimately left his line manager in tears. And so the issues were really over his behavior and his conduct. But obviously, in the background was his disability. And although it didn't arise on this appeal, there were obviously other issues. The claimant was disciplined over a number of matters, and ultimately he left. And so a number of tribunal claims followed from that.
And I can see in the judgment from the EAT, the disabilities were listed as dyslexia, Asperger's or ASD, neurodiversity, and left-sided hearing loss. Could you give us a bit of context around the claimant's disabilities and what he said about them and what adjustments that he needed?
Well, as you can see, obviously this was a complex case. It was a number of potentially overlapping disabilities. Obviously the hearing loss was more conventional, but the others were mental health related, and obviously certainly better understood now than they were, but obviously are challenging for the employer. So for example, there was acceptance that those were amounted to disabilities and that the claimant had those disabilities. What wasn't agreed was what actually arose from those disabilities. Now, there was agreement that, for example, if the claimant was given instructions verbally, that he needed those to be followed up in writing so that he could, be sure of what he'd been asked to do. And there were some physical adjustments made for him in the workplace. So, for example, he was allowed to use, quite unusually in an employment context, he was allowed to use a special pen to record conversations. So he could go back and listen to it afterwards to make sure, this is unlike all the usual covert recording cases, he's actually allowed to record in order that he could, where there was a danger he might have misunderstood, he could go back and clarify. So those were accepted as some things that arose from his disability. And obviously, I don't think it was particularized particularly which one, but obviously there were multiple disabilities in play. What wasn't agreed, and what was the focus of the appeal essentially, was that there were two other some things that the claimant was contending for, which he said arose in consequence of his disability. One of those was, he said there was a need that for him not to be approached in a seemingly confrontational manner. That's obviously, you can see why that would present a difficulty in any kind of management scenario. And that wasn't accepted by the respondent. And the other was, he said that he had a need when talking to colleagues to stand up, to speak to them. And again, the respondent didn't accept that. So those were essentially the two some things that weren't accepted and that then became relevant on the appeal.
And so what were the legal issues involved in the appeal then? Were they, or with the tribunal, around that causation of the something and the behaviour?
Because on the face of it, the issues were with the claimant's conduct and with his behaviour. But obviously the question for the tribunal was, to what extent was that behaviour related to his disability, and not even directly related? Because obviously this is the sort of problem with this sort of second stage removed in disability section 15 claims, is to what extent is the disability in the background effectively. Now the claimant was essentially saying, that the behaviour the respondent objected to was all causally related to his disability. The respondent was saying, well, and his line manager said, we don't accept that any disability removes the need to behave appropriately. And you can see how that it would be an increasingly topical issue, I think, for a lot of employers in situations where these issues arise.
So what happened at the employment tribunal? Presumably the claimant lost, otherwise he wouldn't have been appealing. So what happened there?
Well, on the section 15, on the disability, discrimination arising from disability claim, there was quite a bit of medical evidence before the tribunal, which is important. We'll come back to that. The claimant had been seen a number of times by occupational health over the years, because these incidents hadn't all happened at one time. There was over a period of years. He had been seen by occupational health. He'd been seen by a psychologist and also by a psychiatrist. So there was quite a bit of medical evidence before the tribunal. And they, from those reports, there were findings that, for example, if the claimant was in a stressful or situation or where there was anxiety or conflict, his speech and his tone could come across as inappropriate, and he might adopt aggressive mannerisms or a raised voice. But in terms of the actual some things that were contested, there was no mention in the medical evidence of any need for him to stand up, for example. And so the tribunal had to assess essentially the evidence before it, which included the claimant's evidence. And the claimant's evidence was, in fact, that because the tribunal was wondering, was he standing up in order to better understand others, because he had this hearing loss? Was he looking to lip read? In fact, the claimant's evidence was that he stood up so they could hear him, because the tribunal struggled to understand and ultimately didn't accept that was something arising from his disability. The managers were concerned that he had quite a loud voice, that he was quite disruptive, and they'd asked him not to stand up. And so this was this question of, was this arising from his disability? And the tribunal's conclusion on the evidence was that he stood up essentially because it was a habit of his, that he liked to, that he chose to do that. Effectively, it didn't arise from his disability. And the second, in terms of those contested issues, whether it was appropriate to approach him confrontationally, the tribunal looked at the incidents of where his behaviour was said to have been inappropriate. And obviously with those findings in mind as to how he would react and his hand gestures and so on, but they looked at what the triggers for those incidents were, whether they were where he'd been given instructions that had been changed and he hadn't had it in writing or something like that. And actually they found that ultimately the behaviour that was complained of didn't stem from, say, his Asperger's, but ultimately he didn't like being told what to do, and he didn't like being criticised. And you can see that's obviously I'm sure that's a finding he didn't like, but you can see why that was obviously a very difficult one for the tribunal. And so what they found ultimately was that there wasn't any link between the behaviour, between the somethings that were in issue and the claimant's disability. And so for that reason, he lost at tribunal.
I see. So just pausing there then, from a case preparation point of view for a claimant, quite important to get that medical evidence to show the link between whatever the arising is and the disability itself, because it sounds like that piece was missing in this case. Is that fair?
Well, it is. And this, of course, is the point. Whether you're a claimant or a respondent, medical evidence is going to be central, because essentially, part of the point that arose on appeal was the claimant was saying, well, I've consistently linked my disability to my behaviour. And he cited an example of some notes in one of his appraisals where the respondent had noted, the way you talk to customers seems to be affected by your disability. So he was saying, effectively, it's agreed that this arises from my disability. But actually, the tribunal, the Employment Appeal Tribunal, found that tribunal was entitled to reject the claimant's self sort of analysis and to focus on what the medical evidence was. So for a claimant, absolutely, because obviously it's for the claimant to plead what the something arising from is, the claimant and their advisors. It's all too easy to fall into the sort of trap to say, I think it's this, therefore it's this. They get you, in order for a claim to succeed, the tribunal is going to have to be satisfied on the evidence, and where that's contested, the claimant's self-diagnosis may not be enough. Yeah. So yes, from the respondent's point of view, you want to be, obviously getting occupational health involved at an early stage, because of this minefield of not knowing what the some things may be. If you know you have somebody with a disability, obviously you've got certain duties and responsibilities, but the more you understand what may arise from it, as well as simply the disability itself, the better. And also for the claimant, not because you go around planning a claim all the time, but in the context of seeing your doctor or whatever, in respect of your condition, then that evidence is going to be important if you do then want to bring a claim.
Yeah, super. So moving to the EAT appeal then, what did the claimant appeal? What were his grounds of appeal and what was the appeal about?
Well, essentially, he was arguing that, looking at the reasoning of the tribunal, the only way they could have come to the finding that they did, i.e. rejecting that part of the claim, was that they had misapplied this broad test of causation that's in section 15. Although he didn't actually say that tribunal's finding was perverse, which obviously would be the only way of overturning the factual finding, he did argue that it was contrary to the medical evidence, and that again, as I said, he relied on the fact that the respondent had also seemingly made this link between his behaviour and his disability. So he's effectively saying, I say it's because of this, the respondent accepts that. And the tribunal was criticised for effectively dismissing the idea that the disability was the primary cause, but not looking at whether it could have contributed to it. Because obviously, for Section 15 claims, the disability only needs to be a sort of more than trivial sort of connection with the something, or the treatment rather, so that it's not the primary reason. If it's not the main reason, then it doesn't apply. So it was arguing the tribunal effectively misapplied the test. And that was,
yeah, I can
sorry, go on.
I can see that the EAT is pretty critical about the Employment Tribunal's judgment for various reasons. But could you just help us with, they sort of go off on a bit of a tangent about Section 123, which is bringing things within a continuing act or conduct extending over a period. So what was going on there from the EAT's perspective?
Well, I think the primary criticism of the judgment was that it was very strangely structured, because there were a number of different issues here, including whether the claims had been brought in time. Obviously, being a jurisdictional point, that's fundamental and is ordinarily dealt with at the outset, because obviously if the claim's not in time, there's no need to consider it any further. The way, and again, anyone who's read a tribunal judgment will be familiar with the tribunal will make findings of fact, and it will go on to apply the law to those facts, and jurisdictional points will typically be taken at the beginning because there's no need to consider it further. In this case, the tribunal had essentially set out some of its conclusions and then gone on to make findings of fact. It had made findings about time points mixed up with findings about the merits of the case, and it made for a very confusing judgment. So the EAT was critical of that. Having said that, didn't actually undermine the reasoning, and having sort of reworked the judgment into the order it should have been, the tribunal, the EAT accepted the reasoning of the tribunal, because the tribunal had made findings, albeit in this unusual way, but in this unstructured way, it had made findings that the claimant's conduct and his behaviour was not because of his disability. His disability played no part at all in it. It was because ultimately he had a short temper. He didn't like being told what to do. That was their finding. And so because there was no connection to the disability, it wasn't a question of then was a lesser role played by the disability. And so in fact, the order in which the tribunal approached the questions didn't in fact matter, because there are two ways that the tribunal can approach this sort of a claim under Section 15. You can either look at what is the something, identify the something, the consequence of the disability, and then work from there. Or the tribunal can start with the treatment that's complained of. And in this case, the tribunal started by looking at what is the something arising from, identify that sort of consequence. Having found that it did not arise from the disability, there was no need then for it to go and consider the causation for the unfavourable treatment. And the tribunal, EAT, upheld that, although, as I say, it was quite critical of the way the tribunal got there.
I see. So is that why the employee ultimately lost his case overall, because of that?
Well, it is, because, as I say, having that finding obviously wasn't challenged by as being perverse. Therefore, that finding of fact stood, and the point, therefore, that the test had been misapplied effectively missed the point, because there was no need for the tribunal to consider what the reason for the unfavourable treatment was, because if there was no something, then that was the end of that aspect of the claim.
I mean, I think it would perhaps not come as a surprise to a lot of people familiar with neurodiverse conditions that having a short temper absolutely can arise from ASD or Asperger's or any neurodiverse condition. So with that in mind, have you got any tips for case preparation, for medical evidence, or how the claimant could have done better, really?
Well, this is the difficult thing, as I say, particularly where you're dealing with mental health issues, where it is a lot more difficult to establish causal links on a lay basis, as opposed to when you're dealing with a physical disability. It can be a lot more straightforward. And I should say, this judgment does not find that, as a rule, having a short temper doesn't arise from any one of those disabilities. All these cases are necessarily fact specific, and that should be emphasized. But that is the whole reason why the medical evidence must also be fact specific. You can't simply say, here's a web page saying, you know, people with Asperger's have X, Y, Z. The tribunal will be looking at what are the facts of your case, what are the well, you know, because in this case, the claimant had some symptoms of Asperger's. He had neurodiversity. It wasn't further defined in the EAT's judgment. You know, they're going to be, if you consider the number of conditions that may arise, the burden is going to be on the claimant, who's got to establish the something to evidence that. It's obviously going to be half of the respondent to do that. The respondent may commission its own, you know, reports as part of its duty as the employer, but really the claimant's got to be particularizing their claim and being as focused as they can and supporting that with evidence where they can. Because as you can see on this case, the tribunal was able to make findings that in fact it didn't arise from the disabilities contended for.
That's really interesting. Thank you so much, Richard. And there aren't that many Section 15 cases, so it's actually quite interesting and useful to have another appellate level decision that just helps define causation and what's required. Thank you so much. And that is the end of our little romp through that case, which hopefully you've found useful. We'll put the case reference on the website so that you can see it. Thanks very much. Bye.